Uriah Woods against the state.
Thank you.
Now,
Yes.
before you resume your submission for the Suspending Convention, there's a point I wanted to raise,
Right.
which I don't think perhaps affects you quite as much as it might affect Mr. Fitzgerald, and so I want to raise it so as to give Mr. Fitzgerald time to think about his
Thank you,
You won't need,
response.
you won't need time.
Well, I'm sure I will. I'll take a note.
What has occurred to me is this. If we accept the argument presented yesterday by Mr. Hall that there was a misdirection on provocation, and if we don't regard this as an appropriate case to apply the proviso, so there are two ifs there, quite big ones, but if that's the position that we find ourselves in, then Mr. Hall submits that we should remit to the Court of Appeal in Trinidad, and they would then have to do one of two things. They could either quash the conviction and authorize a fresh prosecution, or they could substitute a conviction for manslaughter and impose an appropriate sentence. Now, if the Court of Appeal were to authorize a fresh prosecution and the case were to go to trial, it would then be open to the defendant, the present appellant, to run a defense of diminished responsibility as well as provocation, and to lead any evidence bearing on that issue, including the evidence of psychiatrists and forensic psychologists. If, on the other hand, the Court of Appeal were to substitute a conviction for manslaughter and proceed to sentence, then I presume it would also be possible to place before the sentencing judges the material bearing on mental capacity and possible delusions.
Yes.
Now, if that's so, I'm wondering what in that situation would the diminished responsibility ground of appeal actually add anything? Because if it were successful, it would, it seems to me, have the same result. It would have the result that we would again be remitting to the Court of Appeal for them to hear evidence bearing on diminished responsibility. And if they were to accept that evidence, then they would again have a choice either to quash the conviction and authorize a fresh prosecution, or to substitute a conviction for manslaughter and proceed to sentence. So, in other words, it looks to me as if this is a double-barreled appeal. Mr. Fitzgerald, at the moment, I'm inclined to think, may bring down his quarry successfully with one barrel, and I'm wondering whether firing the second barrel actually adds anything to it.
Yes, well, my Lord, if it's any assistance, I'll try and I understand your Lordship's point, and of course, although we've done them as ground 1 and 2, provocation is logically the first. If there's a misdirection
Yeah,
of provocation,
exactly.
then the conviction should be quashed. And I suppose you could simply say we needn't go on to deal with it.
Well, that's what's in my mind,
Yes,
that if we were with you on that, a pure point of law about misdirection,
Yes.
then we could leave all issues about evidence to the Court of Appeal.
Yes, and yes, that's that. Well, my Lord, I think that is right. I think logically, you first address, was there a misdirection at the hearing? If there was, the conviction is unsafe, and you quash it and remit it back to the Court of Appeal.
Yeah.
And as my Lord says, if the Court of Appeal exceeds the point that manslaughter should be substituted, given the point made by my Lord Legate about the possible the great difficulties about a retrial, after
Yeah.
all these years. It's not impossible, but it's very difficult. Then, when it comes to the sentencing, we would be entitled to have a full sentencing hearing. In fact,
Yeah.
I mean, for example, that happened in the Reyes case.
Yeah.
Yes, but I mean, you could call anything you wanted to as mitigation.
Yes, exactly. It'd be a hearing on mitigation.
Interestingly, in the Reyes case, when it was remitted back after the mandatory death penalty was struck down, although the jury had rejected diminished, the judge heard evidence that he was in fact diminished and accepted it and resentenced him on that basis. So that would be, yes, well, my lord, my provisional view would is the logic is...
We won't hold you to a response off the cuff. We'll give you time to think about it and discuss it with Mr. Hall. Yes. But that's why I'm raising it just now, to give you fair notice.
Yes, thank you very much.
Thank you very much, my lord. But if I've understood the point correctly, that obviously does all follow from this court finding that there was a problem with the provocation.
Yeah.
And whilst I said I was going to be short, relatively short on that point, I mean, make no mistake, the Hong Kong court in our submission has got it completely wrong.
Yeah.
And unsurprisingly, you won't be overturning 3 Privy Council cases, and unsurprisingly, Lord Diplock hasn't got it around his neck twice. Because in fact, once we properly understand the way those cases fit together, it has always been, in short, part of the common law.
Yeah. Yes, don't misunderstand me.
Yeah, it doesn't arise.
We haven't heard your reply yet to the argument. I'm just wondering if we accepted the argument, what follows from that?
Yes, but I suppose what I'm really wondering is if it makes any difference to what I have to run. I mean, don't I still have to run everything? Because I mean, I'm happy to run the provocation first, and then your lordships could rise and think about it. I mean, that might save some time, but otherwise I've just got to run everything, haven't I?
Yes, well...
Yes,
I
if
think
you're going to assume that you failed on provocation, then you have to make the other right.
I don't mind running it first. You want to hear the provocation
Yes,
argument?
yes, I want to hear you on both aspects of the appeal.
Shall I do the provocation first? I'll do it in reverse order.
It's entirely a matter for you.
I'll do it in reverse order, just in case. There's a short answer. I don't think there is, but anyway, just in case. Let me reverse the order in which I was going to do this. Okay. Right. So we do just have to trot back through these cases, I'm afraid. So Mancini is the first case, please. Tab 41. Electronic bundle 1280, please. 1280 is the start of the report. It's the House of Lords decision. We can pick up matters at 1288, I think. We can go straight to the relevant passage. So 1288 of the electronic bundle. And the bit I'd like to focus on is the words in the first substantive paragraph. It is not all provocation that would reduce the crime of murder to manslaughter. If your lordship...
Not everyone may perhaps realise that we're sitting underneath the portrait of Lord Simon.
Oh, no, we are. So we have to be nice to him.
This one here is Lord Simon.
Right, we better watch what we say. Not, well, I always do watch what I say, but anyway, yeah, particularly today. Right.
If he starts frowning.
So, yes, it's not picked up the trait from Mona Lisa. Right, so just follow with me, if you wouldn't mind, your lords, please, from that paragraph down. And then about halfway down, there's a reference to the Crown and Lesbini. And the test to be applied is that of the effect of the provocation on a reasonable man. So already at this stage, the common law was utilising the concept of a reasonable man, borrowed from the law of negligence. Provocation grew, I think, from the defence of self-defence. It's got similar concepts wrapped in it. Reasonable man, reasonable response. And then what his lordship does is to say, in applying that test, that is to say, what is the effect of the provocation on a reasonable man, it's important to consider, A, sufficient interval has elapsed, in other words, the cooling off period, which we'll all be familiar with, but B, to take into account the instrument with which the homicide was effected, for to retort in the heat of passion induced by provocation by a simple blow is very different from using a deadly weapon, like a concealed dagger. And this is taken as being one of the first decisions. I'm not sure that's true, that it is the first decision, actually. There's some later dicta that we'll look at that suggests it's not the first decision, but it's one of the earlier decisions, at least articulating in precise terms that you look at the mode and means of the killing as part of the reasonable man test. And that's accepted by my learned friend, I think. He says, well,
so
look...
you'd emphasize the last sentence of that paragraph.
Well, I'll come to the last sentence, the words, my lord, you mean in terms of in short, comma. I'm going to come to those in a minute, because that's important. I'm stopping at the moment just above those words, because that's the operative part of the decision. His lordship is saying the common law test of the reasonable man includes consideration of the mode and means of the killing. So that's how the common law is understood at the time. And there's no doubt about that. If one looks at other authorities at the time and textbooks, that was accepted as being the law. And that's important for reasons that we'll come to. Now, what his lordship then says is, in short, the mode of resentment must bear a reasonable relationship to the provocation if the defence is to be reduced to manslaughter. Now, as a matter of plain and ordinary English, I hope your lords will agree with me that when somebody says in short, what follows is meant to be a summary of the preceding text. All Lord Viscount Simon was intending to do here was effectively to summarise the gist of the effect of looking at the means and mode of the killing in the context of the reasonable man test. In other words, he's saying, look, in short, what the jury needs to think about is this a proportionate response? Because if it's not the sort of thing a reasonable man would have done. And that's all his lordship was saying in that paragraph. What has happened since then, I think this is largely a matter of historical agreement, and we'll come to some decisions later that refer to it, is that sentence has been extrapolated and read as creating a rule. And it's be referred to as the rule of reasonable relationship, or the reasonable relationship rule, or the proportionality rule. And what trial judges apparently began doing was to use that rule to withdraw cases of provocation from the jury. So they say, oh, it's all very interesting that your case, even taking the facts as its highest, is such a disproportionate attack that relying on Lord Simon's dicta in this case, I'm withdrawing it from the jury. So there were effectively two rules that were established in Mancini. One, a reasonable relationship rule, and two, the related rule that rule allowed judges procedurally to take the matter from the jury. Neither of those rules are actually justified by the text in this decision, and that's something that the legislator puts right a few years later in 1957. But what the legislator doesn't change is his lordship's summary of the requirements of the common law. So, sorry if I'm labouring the point. I accept that this decision did create a rule in as much as that's how it was applied, but in actual fact it was never intended to. But that's by the by in a sense, that's how it operated. It wasn't treated as a rule in all cases, I should say. There were some judges that did stick to a faithful interpretation of this decision and only withdrew the case from the jury if there really was no evidence on which it could possibly find, on any view, that provocation was made out. It's discussed a bit more, I don't want to turn this up, but it's just discussed a bit more in the decision of Holmes, which is 1256. I don't want to turn this up, don't need to turn it up, it's just for your Lordship's note. And another case, McCarthy. McCarthy begins at 1293, but the relevant passage is at 1297. That just explains a little bit more about how it operated. So there are two things existing side by side. There's first of all a simple and uncontroversial part of the common law, substantive law, that the reasonable man test includes consideration of the mean and modes of the killing. There's nothing to suggest that Parliament was upset about that or that that was a mischief to which it was directing its collective mind in 1957. The mischief at which Section 3 of the Homicide Act 1957 was aimed at was very particularly two issues. One, extending the substantive law of provocation to words, and therefore overturning the decision in Holmes. And two, getting rid of these rules. But it didn't get rid of the substantive law. So I'd just like to turn up the provision, which is at 603 of the bundle. I can't get 603. Must be somewhere else. Homicide Act, tab 4, I've got the reference wrong, I think 622, sorry, 622, apologies, 622. This is obviously in the same wording as the OAPA Section 4B, Section 3C in Jamaica, Section 4B in Hong Kong, yada yada. Penal Code in Bahamas, etc. Right. Where on a charge of murder, there is evidence on which the jury can find the person charged was provoked, whether by things done or by things said. So that's the parenthesis that overrules Holmes, because Holmes said words aren't enough, except, it did actually say except in really extreme cases, but anyway, that caveat wasn't enough, so that was overturned by the words in parenthesis. And then it's these rules that are then overturned. The question whether the provocation was enough to make a reasonable man do as he did shall be left to be determined by the jury. That's what gets rid of the reasonable relationship rule and gets rid of the related rule that a judge, a trial judge, can intervene and whip it away from the jury if he or she thinks that rule isn't met. That goes, and that's what this section gets rid of.
Well, does it? It gets rid of the procedural. I mean, this is concerned with procedure. The question whether the provocation was enough to make a reasonable man do as he did shall be left to be determined by the jury. If anything, it's affirming the reasonable man
exactly.
rather than
Quite.
abolishing it.
Exactly. That's what we say. We say that the statutory words here give effect to the substantive paragraph in Mancini, because that was the highest decision of the land at the time, and it was also accepted and repeated in Holmes. So you've got two House of Lords decisions in 10 years or so prior to this enactment, making it clear as day that the common law included a requirement to look at whether a reasonable man would have done as he did. And those words reflect and affirm the continuation of that principle. So they don't do away with the substantive law. And so the short answer to all of this is, we say that the words aren't ambiguous. Nothing ambiguous about the words at all. Because as soon as you look at them in their proper context, the words are affirmative of the position of common law that was entrenched by Parliament. And then, therefore, when the Hong Kong courts starts from the proposition that they're somehow obscure or ambiguous, it's making that assessment without actually understanding correctly the historic context. And I'll develop that submission, so I'm not the only person that's said that. It's not me just my ideas. That's how this section has been interpreted. I'm going to come to those authorities now.
I think what is said is that the words "do as he did" are ambiguous because it's unclear as to the level at which that is intended to operate.
Well, the level at which it was intended to operate was the level at which has been described and explained and accepted at the common law, that it goes to the objective man test, whether a reasonable man would have killed in that way.
Well, I mean, if it were reflecting Mancini, in that case, what Lord Simon was speaking about was the instrument with which the homicide was effected, and contrasted retorting with a blow on the one hand would be very different from retorting with a deadly instrument like a concealed dagger.
Yes.
Then talked about the mode. He wasn't focusing on whether, for example, you stab someone once or 50 times, but rather whether it's reasonable to have resort to a knife rather than responding with a fist.
Yes. But that we do say that, I mean, I accept that you could read Mancini in that more restricted way, but in actual fact, what it's been taken to mean, and I think this is accepted, is that if you respond by, say, punching somebody 3 times with an intention to cause them really serious harm and they die, but if you respond compared to stabbing somebody 20 times and they die, in both cases they die, and in both cases the only difference is you're using a different way of killing them, and therefore once you get into that discussion about doing as he did, you just have to look at everything. And that's certainly the way the law has been understood in later cases, is you just look at the whole thing. And in taking into account all of the circumstances, was the response something that a reasonable man... But I accept, if you just look closely and narrowly at the words of Viscount Simon in that case, he could have simply been saying, well, would it have been proportionate to respond with a non-deadly fist or a deadly knife? He could have been simply saying that. But that's not actually how it's been taken. It's being taken.
But the common law doesn't have to remain frozen, and if one asks, well, what is legally relevant to the person's guilt or innocence, or as to whether that should be qualified by being reduced to some lesser offence, it is surely just the fact that they killed with an intent to kill or cause grievous bodily harm. The way in which they went about that makes no difference to whether they're guilty of murder or not, and so it's very hard to see why it should be relevant in deciding whether it should be reduced from murder to manslaughter. Well, that they're not just... If the view is taken that the circumstances would have excused killing with intent to kill, why should it be relevant that they would not have excused going on to administer another set of blows which are irrelevant legally to whether the person's guilty of murder or not?
Well, I think with the greatest respect, that is to look at the defence in overly linguistic terms. I mean, that's how a lawyer looks at it. Well, what's the difference? Because these are the requirements for murder. There's the intent. He was provoked. But that's not how the defence has ever been thought to be operated. It's a concession to a sudden and temporary loss of self-control by someone who's taken and swept up by the moment and does something unthinkable. And it's always been hemmed in by looking at the overall response, because there is a difference between turning around and punching somebody 3 times and them dying, and turning around and stabbing them 3 times and dying. And I'm afraid...
Well, is there, if the punch is done with an intent to kill the person, and it does kill the person, of course it's relevant to whether, in deciding what inferences you draw on the facts.
We say it is for good or bad, has been treated as being very much morally relevant, yes. And it's important to appreciate that the provocation defence has got nothing to do with intention. I mean, the Australian cases, I'll come to those in a minute, but the common law provocation defence has got nothing to do with intention. It's irrelevant. Only the basis of the provocation defence doesn't negative any element of the crime.
It doesn't negative.
No.
It doesn't negative an intention to kill, but it goes some way to explaining it, or some. It's a partial excuse.
Yeah.
Really.
It's a partial excuse for a momentary loss of self-control. It's never been intended to excuse disproportionate attacks, no matter the fact that somebody, I can understand somebody saying, well, look, I've lost self-control, and therefore, how can you judge the actions of what I do by a reasonable man? But in enacting Section 57 and giving effect, the legislation doesn't say to kill or to cause GBH or to develop a murderous intent. It says to do as he did. And the reason it says to do as he did is because of the case law. It was a leading House of Lords decisions at the time. And there is a lot of discussion on the morals and demorals of provocation and how it works. And I wouldn't, there's a huge academic debate about all of this. And it's...
Well, I'm not sure there is there? It'd be helpful if there was some academic discussion of, for example, the Hong Kong case and so on, but we haven't been shown that there is any.
Well, I certainly, I mean, we don't put our case on that basis because we don't come to this court saying it's morally great or morally bad, because we say that it's decided, and it's clear that it's decided, and that's what the law means, and you're just wrong to interpret the legislation as if you're free to do so, unconstrained by the shackles of two leading House of Lords authorities.
Well, we're looking forward to being taken to these authorities.
I have taken those are the big cases. But the next one, just to look at, is Camplin. But just just pausing on the moral question, it is worth considering. It's not in the bundle, but there is a discussion in the Law Commission. Analysis in its investigation and report into homicide that led to the 2009 Act. Is a very important and illuminating discussion about the objective test and how it applies and why it was actually continued in the new legislation and indeed operates in the same way by reference to all the proportionality of the response. Not using those words, but those factors. I don't want to slip into the proportionality rule, but I'm just trying to find a quick way of referring to it. But certainly the Law Commission was of the view that there was a policy basis for not allowing the defence to simply focus on the intention to kill and actually to look at, no, how was the killing done? Was this a sudden and temporary loss of control due to an immediate piece of provocation, or was it someone that went completely over the top? And that's not a question that's simply answered by reference to whether they kill, but by how they kill.
And do we have that in our papers? We
don't have the Law Commission report. No, we don't. But I'm just commending that to your lordship, if you have time to consider it. It's not a massive report, but I think we put the reference in it.
It is. It's Lord Coulson's report, as I recall, and it is massive.
Well, the bit on this isn't very long. I can send along some references to it. I think I was trying not to put huge amounts of authorities and big reports in the bundle, but certainly one of our points in our notice of objection, and we put the Coroner's Act in, is that actually, even now, when Parliament had a chance in England and Wales to look at the law.
Well, if you're relying on it, it'd be helpful to have it rather than to be asked to push around for it.
Is this a report on partial defences to murder in 2004?
I think that's right, isn't it? I have to look at my notice of objection, but I think that's right.
Or is it the report on homicide?
Yes, it would be probably, because it would have preceded the 2009.
Yeah. First thing, they have a consultation.
Well, a lengthy discussion of provocation, certainly.
Yes. I'll find the reference, and I think we do cite it in our notice of objection. But as I say, our case has never been based on having to justify from a freestanding position the moral rightness or wrongness of this rule. Because if we did, we'd have to probably sit for a week and do what Parliament really needs to do. But it's not a blank canvas. So can we just look, please, at Camplin? Camplin, it's at 1114. Sorry, 1106, the case starts, but the bit we want is at 1114. We went to it yesterday.
1114.
1114, yes, at D. This is where we picked it up yesterday, I believe. And in particular, skimming the contents of D and then looking a bit more closely at E.
Did you say letter B?
So E.
E.
E for echo. So just to be clear, Bedder is a case that's concerned with the question of which characteristics one can attribute to the reasonable man. We don't need to worry about it any further than that, but it's a case about that. And that's obviously the subject matter of Camplin. Holmes is the case that decides words can't be provocation. And then Mancini is the case that we've already looked at, that recognises means and mode as a valid part of the investigation into the reasonable man. Refers to the Crown and Haywood in GH, the Law's Compassion to Human Frailty. And then over the page, please, onto 115, and pick the conversation up in between B and C. Reasonable man was a comparatively late arrival in the law of provocation. Refers to the decision of Welsh. Just a bit of history, and then I think we can then pick it back up again in between F and G. Again, as a reference to the Crown and Lesbini. Explains the dual elements of the defence. And then, but until the Act of 1957 was passed, it was a condition precedent which had to be satisfied before any question of applying this dual test could arise. The conduct of the deceased had to be of such a kind as was capable in law of constituting provocation, and that question was for the judge, so that's a procedural rule. And then this House held in Mancini, so this House held in Mancini, so that's the first rule that was held in Mancini, that it was a judge question, not a jury question, whether there was sufficient conduct to constitute legal provocation. And then it says where it also laid down a rule of law that the mode of resentment, for instance, weapon use, must bear a reasonable relation to the kind of violence that constituted the provocation. So that's recognition that that case, deliberately or not, created this rule. But it doesn't, contrary to my learned friend's submissions yesterday, suggest that when Section 3 abolished that rule, that it did anything with the common law itself, namely the scope and extent of the reasonable man test. And then...
Well, it said against you, I think, that the very fact that words were capable of being provocation must have affected a fundamental change in any test of proportionality.
Yes, but the answer to that is why? And the test is exactly the same. Parliament expressed it in the same words, whether a reasonable man would have done as he did, either in response to words or in response to conduct. The only change that was held inferentially to have been made was that identified by Lord Diplock, namely you have to look at gravity of the provocation in order to undertake a proper assessment of whether a reasonable man would have done as the defendant did. That's the only change. There's no link between invoking or introducing words that would in any way interfere with the continuation of the standard common law test of the reasonable man, other than the changes that have been accepted by successive House of Lords decisions to go to the question of gravity.
Once you have the capacity for provocation to be caused by words only, then you're weighing two things that are not commensurable.
Well, that was Parliament's...
Not comparing degrees of violence.
No, that's right. And therefore, Parliament opened up a can of worms by doing that, I accept, because overturning Holmes and saying no, words. But I think all that Parliament can be taken to have meant by that is that actually in certain circumstances, the words used, given the way they might be felt or received by the individual defendant, might actually be so provoking that they could justify a murderous response, even one of significant violence, so long as it wasn't one that's so disproportionate. A reasonable man in the shoes of the defendant, but appreciating how that particular provoking conduct would have appeared to him, which is the test, wouldn't have done it. But I accept, yes, it's obviously requires a bit more work, but it doesn't represent a wholesale change in the law. And if Parliament had intended to overrule Mancini and Holmes in those aspects of the decisions, I think it would have said so. And certainly nothing in Camplin supports the proposition that that's what happened. Bear with me just a moment so I can pick up, please, where I am. I think there's a bit more I need to go to in this case. So 117, we can pick up, please, the judgment at C. So His Lordship set out Section 3 of the Homicide Act and explains here the changes it makes. It brings about two important changes in the law. First, this is at CD, it abolishes all previous rules of law as to what can or cannot count as provocation. And in particular, save in two exceptional cases that my learned friend discussed yesterday, words unaccompanied by violence could not do so. So it abolishes that. Secondly, dealing with the procedural rule, it makes it clear that there was any evidence that the accused himself lost self-control in consequence of a provoking act was bound to leave to the jury the question, this is at DE, which is one of opinion, not law, whether a reasonable man might have reacted to that provocation as the accused did.
Yeah, in the Hong Kong case yesterday, we saw how the judgment identified four possible meanings of that phrase.
Yes.
And, I'm not sure we haven't so far, at any rate, seen in the English authorities any attempt to analyse it to that level of specificity.
Well, no, I suppose at the moment I'm dealing with the argument that this case stood for the proposition that when you threw the baby out with the bathwater, and I'm just saying that didn't happen. All that went were the rules, and therefore Mancini's the good authority that it always was and was always understood to be. But and then at 118 of the bundle, so the next page, 118 at A, His Lordship describes the characteristics of the ordinary person with ordinary powers of self-control. And then he says, in between A and B, a crucial factor in the defence of provocation from earliest times has been the relationship between the gravity of the provocation and the way in which the accused retaliated, both being judged by the social standards of the day. And then he refers to Hale in the 17th century about chopping someone with a sword if they pulled your nose, which apparently was acceptable at the time. And then he refers to Mancini and my Lord Doherty's point at that time being primarily concerned about degrees of violence. And then he gets into the very point made by my Lord Doherty. Well, once you introduce words into the equation, you've got to box a bit smarter because you've got to try and work into the test something that considers how those words might have been received by the defendant. And then you get into this complex test, which is a bit difficult to justify, frankly, on the words of the section, but nonetheless is worked into it, where you look at the gravity as experienced by the individual defendant, and then you throw that into the mix when looking at the overall proportionality of the response. That's a concession, effectively, because you look at the subjective, you look at a subjective element within the objective test, because you look at how the gravity, how the provocation would have been received and understood by the defendant when looking at the gravity to him. That's how they work.
Well, you look at certain characteristics,
Yeah.
take kind of certain characteristics.
So how would he or she have viewed the words spoken? Because obviously, the words on their own might not justify any kind of violent response, but you've got to look at who they're directed at and why it might matter to them. But it certainly doesn't dispose of the law more generally. And certainly I take His Lordship there to be maintaining that even though Section 3 has come in, the basic principle in Mancini remains good. He's referring to Mancini. He's not saying it's no longer good law. He's saying, no, well, Mancini, you look at what the defendant did. Right, next case is Nathaniel Brown, which is an English Court of Appeal case. That's 1067 of the bundle, please. So 1067 is where it starts. It's a case from 1972. It's an English Court of Appeal authority. And it deals expressly with Section 3 and its impact upon the decisions in Mancini. And we can pick up the judgment, please, on page 1070. And one can see the submission made by counsel in between B and C on that page. What Mr. Temple complains of is that the judge misdirected the jury on the reasonable relationship rule. The mode of retaliation must bear a reasonable relationship to the provocation. That brings into question the effect of Section 3 of the Homicide Act. They then cite the relevant passage from the Mancini decision. And the Court of Appeal then says between E and F that was never meant to be a statement of legal principle, notes that that was also the view taken by the editors of Russell on crime. In any event, you now have to look at it in the light of Section 3. It refers to the Walker case, preceding this case in 1969. The obiter considered the possible impact of Section 3 on the Mancini decision. But even in that case, and one can see the text extracted at the top of 1071, this is text extracted from the Walker case. See the force in this submission, which may well be correct, i.e. that the rule has gone. But plainly, one vital element for the jury's consideration in all these cases is the proportion between the provocation and the retaliation. And then there's reference to Lord Devlin's judgment in Li Chun Chien. It's never been the law that someone completely loses his temper and some trivial provocation reacts with gross and savage violence can hope for a verdict of manslaughter on grounds of provocation. So it didn't matter in that case, the Walker case, because the summing up in the whole was reflected the test. But then there's reference to Phillips and the Queen, which is judgment of Lord Diplock, in which the relevant passage is extracted there. And again, the purpose of Section 3 of the OAPA in Jamaica, which is in identical terms to the OAPA in Trinidad and the Homicide Act 1957 in England, was A, to abolish the rule that words can never amount to provocation, and then 2, to leave exclusively to the jury the function of deciding whether or not a reasonable man would have reacted to the provocation in the way in which the defendant did. This explicitly recognises that the jury have to consider, once they've reached the conclusion that the person charged was in fact provoked, whether the provocation would have made a reasonable man lose his self-control, but whether, having lost his self-control, he would have retaliated in the same way as the person charged in fact did. That is a faithful explanation of the common law as it was recounted in Mancini, and was understood universally from that decision, as far as I know, up until this time. Lord Diplock is not making an error there or misunderstanding the law. He is correctly explaining how the common law was understood and that it continued after Section 3, because the only change made was to the rules concerning the way in which the objective test operates. But what Lord Diplock did say in the Phillips case is that you have to be careful when you make a direction not to fall back into expressing it as a rule, and that's the point made at G to H at the bottom. And then on the next page, at 1072, between A and B, in the view of this court, when considering whether the provocation was enough to make a reasonable man do as the accused did, it's relevant for a jury to compare the words or acts, or both, that are put forward as provocation with the nature of the act committed. It may be, for instance, that a jury might find that the accused act was so disproportionate to the provocation that no reasonable man would have so acted. And then at the bottom of that page, we can see, beginning at E to F, an extract of the trial judge's summary to the jury in that particular case that was under appeal in Brown and Nathaniel Brown. And one can see just before G, the direction to the jury, which the Court of Appeal said was unremarkable, was you have to find that the provocation not only did in fact cause this prisoner to lose self-control, but was of such nature that it would cause any reasonable person to lose their self-control in the same way. And then the example given, that again is considered by the Court of Appeal as far as to be unobjectionable, is that it may be that one set of circumstances could amount to provocation, to provoke a man to strike his wife a blow with his fist which might cause her death, to grab her round the throat and throttle her in a moment of anger, both killing her, but where, as here, a lethal weapon in the form of a razor has been used, and used in acts which objectively regarded must, you may think, be of great savagery, then you may think it would not be right to say that a reasonable man would have been provoked to that reaction, unless the provocation was very grave. So far, the court, I'm on 1073, just before B, thinks the direction is unobjectionable on any view. Went on to then consider some other bits of the direction which were more problematic, although in the end the judge's judge's directions were held not to have fatally flawed, were held not to have created fundamental unfairness, and therefore the conviction was upheld. But the point I want to focus on is just these passages. It plainly shows in our submission how that test was understood and applied. Just briefly look as well at tab 34, which is electronic bundle number 1130. It's just a case note. I don't think we've been able to find the underlying transcript of the judgment, but it's another case that is cited in the texts. The offence was manslaughter due to provocation.
Sorry, which page was this? I didn't note.
1130.
Thank you.
And the Homicide Act itself?
It's a case comment. It's a case report. I don't know why the head note refers to the homicide. I think it's because the Court of Appeal in this case construed Section 3 of the Homicide Act. So the title at the top of the page is meant to tell you what the case comment's about, but it also just tells you what happened in the case.
The name of the case is what?
Clark.
It is Clark. It's cited, right?
Yes, so it's case. It's Crown and Clark, 1991, Criminal Law Review 383.
Thank you.
And it's really the bottom text, 5 lines up from the bottom. However, the court preferred the Crown's submission that under the Homicide Act, Section 3, the jury is required to consider the whole course of C's conduct in deciding the question of provocation, although some factors, disposal of the body, might be too remote. The acts surrounding the electrocution were part of the circumstances from which C's state of mind must be considered, and the question whether a reasonable man would, quote unquote, do as he did was not limited by words to in causing the death of the deceased. You have to look at all the circumstances. That's consistently how, since at least the 1940s, but I suspect for reasons I'll come to in a moment, even before that, consistently how the common law has been understood. Although we've seen some of the relevant passages from it, I would like us just to briefly please turn up the decision.
The note by Professor Smith was very critical of this judgment. We don't know who it's by. We don't know if it was a reserved judgment.
It's a continuing theme, is my point. I mean, it's completely consistent with Nathaniel Brown. And there were various different complaints about it, but that was always understood to be the law. That's my point. I mean, I'm sure I can pull out some more decisions that fill in the gaps. But I've certainly never seen We've got 3 Privy Council decisions, by the way, from different jurisdictions that all say the same thing. But we'll come to those in a second. But I've never seen a decision that says, oh, all you look at in a provocation case is whether or not somebody, a reasonable man, would have killed. I've just never seen that. No one's put one before the board. So the Hong Kong decision 2017, on any view, is the first decision that certainly anybody's been able to put before the board where anybody has construed these words in that way. And it would involve departing, as I say, from several Privy Council decisions. We'll come to that one now, one of those now, which is Phillips. We've already seen some of the relevant parts of the decision because they're extracted into the Nathaniel Brown case. But at 930 of the electronic bundle is the beginning of the case. We can pull up the beginning of the judgment, which is on page 934 at H at the bottom. Explains that there was a dispute shortly before the killing at which there was a threat of violence. And then explains over the page the following a quarrel between the victim and his mother, in the course of which they spat at each other. The appellant then seized a machete from a bag which his mother was carrying and rained 6 blows on the victim. Automatism was run at trial. Counsel disclaimed any reliance on provocation. Then we can pick up the discussion at C. Reference to Mancini and the judge thinking it right to direct the question of provocation, to direct the jury on the question of provocation nonetheless, despite disclaimer by counsel. And effectively, the trial judge had directed the jury in this case along the lines of the reasonable proportionality or the reasonable relationship. He basically said to the jury, look, if you don't think there's a reasonable relationship here before, on the facts, then the case fails. And what the Privy Council says is, well, that's true that the rule has gone, but the basic gist of that consideration remains relevant. And we can just pick up, please, in between G and H at the bottom of page 935, the relevant bit from the judge's summing up. It can be read fairly briefly, it's just to give a flavour of what the judge was saying. And it goes over onto the page at 936, between A and C. And at C to D, the Court of Appeal treated this passage as being similar in effect to the directions which had been held to be objectionable in the Crown and Bennett Jamaican case, because they sound quite a lot like the reasonable relationship rule. And it's important to say to juries, there's no rule here. You need to look at all the facts and decide for yourself whether a reasonable man might well have done something along these lines. You don't have to say there's no rule of reasonable relationship. That's the point. And then at E to F, Lord Diplock says, well, I don't know, actually. If you look at the passage complained of, the learned judge left it fairly and squarely to the jury to decide whether or not a reasonable man would react in the way in which the appellant had reacted. He avoided the more abstract expression, reasonable relationship. And then right at the bottom, underneath H, in their lordship's view, it is beyond question that a common law by which the matter was regulated both in Jamaica and in England until the legislation cited above, the relationship between the degree of retaliation and the nature of the provocation was a relevant factor. it was sufficient to refer to the words of Viscount Simon. In short, mode of resentment must bear a reasonable relationship, etc. This is an elliptic way of saying that the provocation, that the reaction of the defendant to the provocation must not exceed what would have been the reaction of a reasonable man. In other words, he was simply saying that it's part of the reasonable man test. It's the same point made in Nathaniel Brown. It's not a legal rule, it's just part of the common law test. Then again, we see the passage that we've already seen where he explains the only changes brought about by the OAPA in Jamaica, copying the Homicide Act in England. We say mutatis mutandis, the legislation in Trinidad. And then goes on at D. The question is whether is would or is the same provocation in the same way as the defendant did. And then at F to G, emphasising again, once you've reached the conclusion that the person was provoked to lose self-control, you have to go on and consider whether he would have retaliated in the same way as the person charged in fact did. And then the policy is at least partially explained at G to H. And over the page onto 938 at A to B. His Lordship explains, presumably with the agreement of the other judges who he's giving judgment on their behalf, that there's nothing incoherent about looking at the means and mode of the killing. There's different types of responses might justify an excuse, and other types of responses in law might not. Irrespective, must be, irrespective of the fact that legally all that matters to us lawyers is, well, did he or did he not commit the offence with the requisite intent? Provocation is just not focused on that. It's a common sense, factual response, and a limited one at that.
The examples he gives between A and B are again all concerned with what one might call or what Lord Simon called the instrument, whether it's a fist or a weapon or just words.
Yes, but once you get into that debate, you're then juxtaposing cases where somebody kills with a fist or kills with a knife, and therefore query what's the difference between, once you're in that arena, how can you stop the ball at saying, well, I can't look at 20 blows rather than 50 blows? And of course, bearing in mind that it is meant to be hemmed in anyway by sudden and temporary loss of self-control. I don't quite know where, I've not managed to pinpoint how the cases started galloping in the direction of frenzied responses. I think it was because people said, or some people said to judges, well, look, a frenzied response is a good evidential basis for saying that I've lost control. But it's also quite a good way of the defence not applying, because it's a sudden and temporary loss of self-control that we're talking about here. It's flipping around, doing the unthinkable. It's not laying into someone 216 times in a taxi. That was the facts of the Hong Kong case. I mean, the idea that you can rely on provocation when someone's stabbed someone 216 times is, frankly, when you actually drill down into the history of this defence, is ridiculous.
The actual words used in the direction which the Lordships and Phillips thought was impeccable used the general words in the way that the appellant did, which is consistent with both Category 2 and Category 3 of the Hong Kong court's analysis. Isn't it?
I'm not sure I fully appreciate how you can necessarily dissect the different meanings of do as he did into those four categories, to be honest. I mean, it's simply a question of looking at what the defendant did and then asking whether a reasonable man facing that degree of provocation might have done a similar sort of thing. And this artificial dissection into these hermetically sealed different interpretations of the words just don't do the process of statutory interpretation any justice. You just have to look at the words and understand that they reflected the common law test, and then look at the authorities which say what the common law test meant. And if you do that, the answer's clear. It's only if you go off from that process and start looking at the words in the abstract and then theorising about different abstract meanings that could be ascribed to these different terms that you end up in this mess that the Hong Kong courts found itself in. You don't need to do any of that. You just need to look at the cases which explain what the test meant and explain why Parliament used the words that they did.
So, as I understand you, the effect of Section 3 of the Homicide Act in this regard was simply to avoid the superimposition of Lord Simon's elliptical summary of the rule upon the rule itself.
Yeah, basically, yeah. It's just two things: to stop juries being told,
yes, and to avoid juries,
and to avoid judges stealing the question from the jury. And therefore, the question of whether the defendant would have, whether the reasonable man might have done what the defendant did, all of it becomes a matter that's just left to the jury's good common sense as to whether they think that that type of killing is something that they think could be justified and reduced to manslaughter, whether it's a set of facts that actually, you know, are just too extreme for a jury, not a judge, not lawyers, a jury to excuse on that basis. Well, can I... Logan, having moaned and whinged about my learned friend putting in cases, we of course then put in a case, so I apologise about that, but there's a case that should have made its way to your lordships and has made its way to my learned friends, called Logan. And I don't want to get caught up on it. I don't know if, in as much as I don't want to spend a long time on it, but could I just commend to the board, it's a Privy Council case from Belize, and although it's dealing with the meaning of a statute in Belize, the origins of which Mr. Fitzgerald was kindly explaining to me this morning, apparently written by a civil servant, and may or may not reflect the common law. But anyway, it's meant to reflect the common law. In 1880, yes. Anyway, during the course...
The case is called?
Logan.
L-O-G-N.
I apologise, my lord. I thought it would have been put on your desk, but it doesn't matter. It's 1996, appeal cases 871. Don't even really need to turn it up. I can just give your lordships.
Is it in the electronic bundle?
It's not in the electronic bundle.
Been sent separately, put into our folders separately.
Yes, it's in a supplementary respondents bundle.
Sorry.
Yeah, it's the bottom one.
We vacillate between trying not to over-proliferate authorities as per the practice direction, but not turning up at court unequipped. And this one's fallen through the net, so there it is. And I just commend to your lordships 887 of the report, A right the way through to G, because it just gives a useful summary of the common law as it was understood, and effectively clarifies that the thrust of the judgment in Mancini remains common sense criteria highly relevant to the defence of provocation. That's all. Don't need to go to it, it's just there. Acott, and I'm only going to this decision, I should say, because we spent some time on it yesterday, and because it appears to have been, a somewhat unusual reading of that case in the Hong Kong judgment, but it's at Electronic Bundle 1019. Nope. Why are my references all wrong? Tab 25. Sorry, 1014. Apologies. Judgment of Lord Steyn.
Who also wrote the judgment in the case you just took us through, Logan.
Yes. And his lordship explains at F onwards on page 1018 the effect of section 3 of the Homicide Act. The objective test left to the jury.
Sorry, 1018 letter
G,
yes.
F down to
yes,
H.
got it. Thank you.
Thank you. Just explains the 3 primary effects of that legislative intervention. And then over the page on 1019, A to B, again, just affirming the point that I've been discussing with my Lord Sir Anthony, that it was doing away with the rule, not the law. And that's the reference there at B to C to Logan. And at C, Camplin, which is the case we've already been to, this case interprets Lord Diplock's judgment in Camplin in the same way that I've commended to the board, which is reading it as a case that affirms that it's the rules linked with the objective requirement that have gone. And then at 1020, right at the bottom of the page, although there was no longer a rule of proportionality.
Sorry, what
My Lord, page 1020.
yeah.
Right.
Oh, the very last line.
Very last line, please. I'm just going to read this quite slowly because we spent a bit of time on it during my learned friend's submissions yesterday. It's quite tricky. Although there is no longer a rule of proportionality as between provocation and retaliation, the concept of proportionality is nevertheless still an important factual element in the objective inquiry. Pausing there, no objection and no uncertainty so far. It's relevant because the jury needs to think about whether a reasonable man would have done something along the same lines as the defendant. So no problem so far.
Well, I have a problem, sir.
Oh, okay.
I've been struggling with this sentence.
Yes.
It's not clear to me whether he's saying there's no longer a rule of proportionality, no longer a rule, or whether he's saying it's no longer a relevant consideration for the jury.
Yes, I think if we just start that sentence and bear in mind what his lordship said on page 1019, and in particular 1019C, the House of Lords in Camplin held that Section 3 abolished all previous rules linked to the objective element, and then talks about the questions therefore becoming as a matter of opinion within the sole province of the jury. D.
I'm sorry to interrupt, but
Yes.
it may be helpful to begin a little bit further up the page.
Yes.
Just below B,
Yes.
or just above B perhaps,
Yes.
by converting common sense criteria into fixed rules of law.
Yes. Yes.
That's a mischief, as it were, of the legislation address.
Yes.
Thus, the rule was laid down that disproportionate retaliation may bar the defence, or it was later put, the retaliation must bear a reasonable relationship to the provocation received. He goes on, plainly proportionality was a highly relevant matter to a defence of provocation. So that perhaps answers Lord Lloyd Jones' question.
Yes. And that's, by the way, reflecting what he also said in Logan.
So the mischief was withdrawing cases from the jury on the ground of fixed rules of law.
That's the mischief at which the statute is aimed, and therefore, sorry, I did take your lordship to that bit, but I was probably trying to rush through it a bit.
Yes, and then at D, he tells us about the effect of Campion.
Yes.
That holds that Section 3 abolished the power of a judge to withdraw provocation on the ground there was no evidence on which the jury could find that a reasonable man would have been provoked as the defendant was. Henceforth, the objective requirement was to be regarded as an issue of fact, or more realistically, opinion, within the sole province of the jury. So it's a matter of their opinion. It's a relevant consideration for them, seems to be, where there is a reasonable relationship between the retaliation and the provocation. But there's no rule of law barring the defence if the judge considers that no reasonable jury could consider that there was such a relationship.
Yes. Because one can imagine trying to assist a jury.
Well, I can see it can be read in that way, but the essential question is the way in which proportionality is relevant to the objective inquiry. And it may be said, I think it is said actually, that it is actually relevant in a different way because it's relevant to assessing the power of the provocation.
Well, it may help just to pause that case and look at.
Still unclear as to quite what is meant by that passage. Clearly, it has to be read in the light of what's gone before, but I'm not sure that necessarily clarifies.
It's this case, by the way. This case, I accept, by the way, doesn't actually go into the question of what does do as he did mean. It's the other cases that do. You know, do as he did means kill in the way that the defendant killed. This case doesn't speak to that issue. But what his lordship is very clearly saying, maybe best just to park that case, because the way that the elements of provocation were deconstructed and explained by my learned friend yesterday, I didn't necessarily recognise. It may be me. I didn't recognise that way. The way I've always viewed provocation is how it was explained by the board in Holly, and it may be useful just to go back to that and look at the elements of provocation, because it's clear that when one does, that the label of disproportionality can only be relevant to the objective test. I mean, the extent of the retaliative response of the defendant may be evidentially relevant to the question of whether he lost self-control. I accept that. I mean, you say to a jury, look how he reacted. He'd obviously lost self-control. I accept that's evidentially relevant. But that's not the objective test. The objective test is only concerned with whether his reaction was one of a reasonable man. And once Lord Steyne is talking about proportionality,
well, he says in terms at the top of 102.1, the concept of proportionality is nevertheless still an important factual element in the objective inquiry.
The objective inquiry is...
So you say he's affirming there that it's relevant for the jury to look at whether there's a relationship between the provocation and the response.
Yes.
And he's saying nothing inconsistent, looking at the whole of the response.
I don't think there's any doubt at all.
Yes, but that still leaves the question as to the way in which it is relevant to the objective inquiry. And the objective inquiry has different elements.
It has two
elements. The Hong Kong court, for example, I think it was the Hong Kong court, suggested that it could be relevant to the first element.
Gravity.
Assessing the degree of provocation.
Yes, but unfortunately, I do say that is confused, I'm afraid.
Proportionality necessarily involves a comparison of two elements.
Exactly.
You can't assess proportionality by just looking at the gravity of one element. Inherent in the concept is relationship between two things.
Exactly. And the objective test contains two limbs. One is an assessment of the gravity of the provocation as experienced by the defendant. That's the point introduced in Appellant to deal with the change in the legislation by allowing words to give rise to provocation. So you look at, but it's not restricted to words, I mean, it's just generally applicable criterion. You look at the gravity of the provocation as experienced by the defendant, taking into account any of his particular characteristics, his religion, his faith, sexuality, blah, blah, blah. And then you juxtapose that, you weigh against that the response, applying the degree of self-control of a reasonable man. And that's the objective test. It's got two elements. Just helpful probably just to look at Holly, because I'm not sure I've seen it deconstructed in the way that it necessarily is in Hong Kong. So Holly's at 636 of the bundle. So just for context, this is the enlarged panel of the Privy Council, impaneled to decide the correctness, in effect, of the House of Lords decision in Morgan Smith, and concerns a discussion effectively about whether the reasonable man should be taken to have some characteristics of the accused. And the really difficult and acute problem facing the court in Smith, which drew a division in the House, was in that case a mental disorder. So the majority say, hang on a second, I understand the reasonable man test, and that's what the statute says. But here we've got someone who's mentally disordered. Can we seriously say that the reasonable man, when applying the reasonable man test, whether a reasonable man would have lost his self-control to do as the defendant did, we have to ignore the fact that the defendant is mentally ill? So you can understand why that question drove a division between the House in that case. And the majority said, no, you can't ignore it. Holly was then impaneled to say, actually, you have to. And you have to, because otherwise you're reaching a conclusion that cuts through the terms of the statute. That's context, really. Apart from...
Part of the thinking be that in those circumstances one might expect the defence of diminished responsibility to have been raised.
Very good. Yeah, well, that's if I may respectfully say, to one of the points that they say in Holly is they say, look, yes, you're in a different defence. Exactly, yeah. But it's interesting in that context just to turn up 640 of the judgment of the majority in Holly, which begins at paragraph 22. I'll leave your lordships to read it, but in effect, the majority says, look, I can understand how you might create a law of provocation that operates in the way that the majority in Smith says it should, but you can't do it.
How do you say it assists us for the present issue?
Well, I'm just prejudicing the minds of the jury by making the point that in 1957, Parliament didn't just pass some piece of legislation, it also effectively entrenched the meaning of provocation And therefore we say that actually the same approach that was taken by the majority in Holly also prevents the decision of the Hong Kong Court of Appeal, because it involves rewriting the statute. Because if you actually understand what the statute means by reference to the cases that it was decided by reference to, it means all the acts of the defendant. And therefore we say mutatis mutandis, what is said in paragraph 22 applies. But I mean, that's slightly naughty of me. But the real reason I actually want to turn to Holly
I mean, the Hong Kong court obviously regarded itself as interpreting the statutory
Yes.
language,
Yeah.
do as he did.
Yes.
That's,
I know.
that's the exercise they were...
That's the exercise they have persuaded themselves they have done, yes. So can I ask your lordships to turn to page 635? 635 of the electronic bundle. And there's just a useful summary there at paragraph 4 and into paragraph 5 and 6 on the next page. I'll just ask your lordships to read. Yeah. So, grateful. So, effectively, ingredient number 1 is, was the person provoked into self-control? That's a factual question. That's the first ingredient. And in establishing that ingredient, you might look at their response evidentially, because obviously if somebody does something that on the face of it is pretty extreme, you may well conclude from that, may well help you, the jury, decide whether they've been provoked. So evidentially, the type of killing may be relevant, but only evidentially, only not the label of disproportionality. That's not going to help you decide whether there's a loss of self-control. It's not relevant. The assessment or the label is not relevant. The objective inquiry has 2 elements to it. The first is, how was the provocation subjectively experienced by the defendant? In broad terms. And then the second element is where you slap onto that, which is the first part of the 2-part test, as my Lord Legate says, of the proportionality test. You're not applying a proportionality test because we're not allowed to, but if you were looking at proportionality, as my Lord Legate says, it's got 2 elements. You stick gravity on one side of the scales, and then you put the ordinary powers of self-control on the other. And that's why Lord Steyn says in Acott, well, obviously proportionality in broad terms is still relevant to the objective inquiry, because the objective inquiry has 2 elements. What's the gravity of the provocation to the accused? And in the light of the provocation as experienced by the accused, what would the ordinary man have done? Proportionality can't be relevant to limb 1 on its own, just gravity. It's only relevant, as my Lord Legate says, because it's juxtaposing or weighing in the balance 2 different considerations.
And you say it's asking the jury to look at all the facts of what actually happened.
Yes.
It's not asking them to dissect those facts with a legal analysis in terms of which ones were necessary to commit the offence of murder and which were not.
It's a common sense, easy, it's a jury test. It's a factual test, got nothing to do with intention or anything else. Can I just quickly turn up, because one point that I think gained some traction yesterday was the point about intention. So can we just turn up, please, the Hong Kong decision at paragraph 90 of that decision, which is Barwick, Chief Justice Barwick's decision.
Sorry, which decision are we looking at?
I'm so sorry, it's the Hong Kong Final Court of Appeal, the Yang Kiang decision, page 1. Let's pick it up at 1539, please. 1539. We can pick it up at paragraph 88. The appellant relied heavily on the approach in the Australian cases dealing with the defence of provocation, but it accepts that those cases have taken a different approach to the English cases. And they say that those cases support a conclusion that the inquiry should be into the question of whether the provocation is sufficient to cause the accused to form an intent to kill simpliciter. And then cited as an example of this, rightly, is Johnson and the important decision of Chief Justice Barwick extracted at 90. We struggled a bit to get the full judgment, but I think we can now get it if my learned friends and the court wishes to see it. But
I had a look at it last night, as it happens.
Right, the difficulty.
Available.
Okay, well, hopefully, your lordship's analysis, hopefully coincides with mine. But if one turns, just leave that judgment for a moment and look at the footnotes. 1598. So 1598, footnote 65, sets out the relevant legislation in New South Wales with which that decision was concerned.
Yes.
And can I just ask your lordships, please, to read that statute? It's a bit convoluted, but focus in particular on section 23, subsection 2C. The last one.
Page of the bundle is this one?
Sorry, 1598, my lord. So I don't know who thought of expressing it in this way, but the point at C, the act. So one of the things that a jury needs to find in order for a provocation defence to work is that the act causing death was done suddenly, in the heat of passion, caused by such provocation without intent to take life. Now, the difficulty, of course, is in order to establish murder, and therefore for the defence of provocation to be relevant, obviously you need to establish, I can tell all the lordships are nodding, knowing where I'm going with all this, but the point is that C must be read as really asking the jury whether the intent to kill was induced by the provocation. And that's why the focus of Chief Justice Barwick is what it is. And it doesn't help in understanding the meaning of the different legislation. It's interesting to note that
there's separate legislation dealing with provocation arising from conduct rather than language gestures.
In New South Wales.
I think this is it. This is, you have to...
This is everything.
This is the
Everything.
test that you had to satisfy in that case. Isn't it?
Yes. So one...
This deals specifically with
Yes.
Yes,
provocation
exactly.
induced
That's it.
by use of grossly insulting language or gestures.
Yes. So what?
Quite
So
specific in that.
that throws into sharp focus the question of intent, because in a sense, paradoxically, what a defendant had to show is that they did intend to kill, but that they only formed that intent because of the things that were done to them by the victim. But that's not how the law of provocation in England and Wales has ever worked, but at least not expressly. I mean, I can see in broad terms it's similar considerations. Interestingly, or maybe not, actually in 1900, I haven't managed to chase this down yet, but I do wonder actually whether the common law in 1900 in England did have a requirement like that, because something very similar to that was cited in Holmes, but was later rejected as being any part of the law of England. But I wonder actually if in 1900, when that piece of legislation was enacted, the common law of provocation in its earlier form did include a requirement like that, because there was some kind of attempt by the judges to link it to malice, because they wanted to somehow justify the defence as interfering with specific intent. And so I suspect actually that legislation may well reflect some old part of the common law. But anyway, it certainly isn't the law that we're dealing with in 1957 as adopted by Trinidad in 1984.
I mean, it's true it hasn't been analysed in this way, but if you think about it, I mean, if it's a partial defence, because effectively it's a partial excuse,
Yes.
what can it be excusing? It doesn't alter in any way the actus reus, but it renders the mens rea partly excusable.
In my submission, it's just a factual defence. It's just accepting that even reasonable people can be driven to do murderous things.
Yeah. What I'm meaning is it must go to the mental element. I mean, it can only bear on the mental element of the offence rather than the deed.
It's a partial excuse for somebody doing something with a murderous intent. Yes, I think I would have to accept that. But it's not been, and there's quite a lot of discussion about the interrelationship between intent and provocation in a case called Chu Cheng, where's Chu Cheng? Sorry. I don't want to turn it up, but just on that point, it does discuss. We'll find that. Tab 40. So it's electronic bundle 802. I don't think it's a good time for me to turn up, but it does discuss and does effectively say, look, this is not about intention. Doesn't attack elements of the intention. It simply says if you've done something that would otherwise be murder, but you were effectively induced into doing it in a way. So I can see how one could extrapolate and move to a situation as the legislator did in New South Wales, but it's just not a step that we've ever taken. And it's not a strong basis on which to reverse interpret the legislation. And happily also it doesn't involve overturning 3 Privy Council decisions. Yes.
The Massi Antonio case didn't turn upon the 1900 legislation. It wasn't a case simply of verbal provocation.
Yes. No, I think that is common law, that case, and as I say...
Similar approach was taken.
Yeah, well, common law, as I say, it may be that the common law has developed in Australia, mindful of bearing in mind that the Chief Justice's decision in the New South Wales case is a part of, as part of the Australian corpus of legal decisions, and maybe it has had a knock-on effect of how the common law jurisdictions in Australia, the federal, in a federated state, interpret and develop the law if they're free to do so.
A note from page 584 of Mr. Justice McHugh's opinion in Asci Antonio, that he observes that in the case of Stingle, the court noted that in this particular field of criminal law, the common law, the codes and other statutory provisions and judicial decisions about them have tended to interact and reflect a degree of unity of underlying notions.
Yes, a degree. It's always something that judges say when they change the law, notwithstanding what the statute says, I'm afraid. We respectfully instead commend to the board the several authoritative statements of English common law and interpretation of the statute, and we say thereby we don't need to get into moralising or even philosophising about the underlying goods or bads about different elements of the test, because it has always been accepted.
The Australian courts certainly haven't seen their approach as being at odds with the
No.
British English approach, because they, in that case, Asci Antonio was often taken to at 581, they cite Mancini, and then Phillips, and then they just add effectively as a footnote that as Barwick, as Chief Justice Barwick pointed out in Johnson, in considering whether an ordinary person could have reacted in the way in which the accused did, it's the formation of an intent to kill is the important consideration rather than the precise form of physical reaction.
Yes.
So they rightly or wrongly, they see themselves as being on the same page as the English courts.
Yes, well, they do, and even weirder, they cite at paragraph 81, which is at 1538 of the electronic bundle, the Nathaniel Brown case. But not the bits that I've been to, but other bits that could be taken as talking about a general test, but not referring to the bits of the judgment that actually make it clear that in England and Wales it looks at the means, mode and manner of the killing. But I was confused when I read the judgment, because it does cite bits of the authorities but doesn't extrapolate from them what we say actually are the key elements of them, which is a clear and consistent, albeit I accept not uncontroversial element of the law, the policy behind which is at least partially explained by Lord Diplock and Phillips, that you look at all the circumstances of the case. And a policy which, by the way, even after careful consideration by the Law Commission in England and Wales, still exists, albeit in a different form in the 2009 Act. Can I just, before leaving this decision, can I also just briefly look at, so I just check my note. Conveniently disappeared. I think, oh, here. So I think, so paragraph 71 to 75, page 1535 of the bundle to 1536 of the bundle. As I say, we looked at these yesterday, and then we get caught up in the discussion in particular at paragraph 74 and 75, where the Hong Kong court, I think, appears to be running with the argument that when the reasonable relationship rule was abolished, that lends support for stopping interpreting or not interpreting do as he did to include the means and mode of killing, and we say that's wrong. It didn't throw the baby out with the bathwater. It kept the essential elements of the common law as recognised in Mancini. And finally, paragraphs 107.
Well, it's the reasonable relationship rule that's gone, though. It's not
Yes.
the relevance of
No.
consideration of
Exactly.
that as a factor.
Exactly. But what I'm not...
We're not saying...
Well, I don't...
irrelevant.
What they say is, meaning for, which involves looking at the method of the killing.
Which paragraph is this?
75 of the Hong Kong judgment.
Thank you.
They say that meaning for, and as I say, I don't really agree with trying to divide up potential meanings as do as he did into these four artificial. I just don't agree with that process at all. But even accepting that, if one looks at paragraph 75, they say meaning for, do as he did, i.e. looking at the method of the killing, would drive considerable support from a conclusion that the reasonable relationship rule does continue to operate, and vice versa. Well, I don't agree. It's completely irrelevant. It's completely irrelevant to the construction of do as he did, because it doesn't go to it. It's just a rule that was wrongly thought to flow from one sentence in a judgment. It doesn't help understanding the meaning of the words. Paragraphs 107 onwards, at page 1545.
You say that what they're arguing there, which is fallacious, is that abolishing the rule signified an intention to abolish reference to the concepts of proportionality altogether.
Or even just the underlying premise that the reasonable man investigation includes looking at everything. And I say that's just a false premise, and then...
But is that what they're saying?
Well, I don't know.
Are they not saying that to interpret do as he did as requiring the precise method of killing meaning would have been supported had the rule been in place as a rule? It's not in place as a rule, so it doesn't support it. It's not saying that the factors are relevant.
Well, I think it is, but it then goes on to say that the fact the rule's been superseded supports one of the other meanings, and by implication it points away from fall, whereas it's neutral.
Having said that, and the reason why I said I think that's what they mean is because, in common with, respectfully, my Lord Dockey, I also thought, well, actually, is that what you're saying? And then they do go on to cite Camplin at 76, and Phillips, and Nathaniel Brown. And I think, well, how can you cite all of those cases if that's what you think? If that's what you think is happening in paragraph 75. I mean, it's obviously a very interesting and thoughtful judgment, and I can't pretend to have done entire justice to it, but there are significant parts of it that I do respectfully say are not right, or at least don't do what they say they do, and don't do what they set out to do. Finally, that's the nicest way I could think of putting it. So paragraph 107 it is dealing with the policy. That don't want to go into the detail of what is said to be the policy, but it is explained by reference to decisions of courts in Australia applying different statutory regimes. New Zealand and Australia. I mean, it's informed by, and why shouldn't it be, the particular developments in that part of the world since they abandoned the motherland and went it alone jurisprudentially, and that's what they've developed and come up with, and that's fine.
That's the paragraph.
That's fine. Yeah, paragraphs 107 to 109. But we can obviously look from a comparative law analysis at these interesting judgments and draw from them what we will. But in my respectful submission, it's my or our trot through the decisions that we've been through this morning that really gives the answer to what the section means. And that coincides happily with the board's unanimous decision in Ramparry, and the board's decision in Phillips, and the board's decision in Logan.
You be taking us to Ramparry?
I wasn't going to,
Quite good.
but I can do, yes. It's really just a case on its facts involving a very severe response to provoking conduct in which the board said, well, even if the judge got the directions wrong, doesn't matter, because the reaction was so disproportionate that you lose anyway. So the decision starts at 980. And then at 982, bottom paragraph, we can pick up the direction to the jury. And analogies were drawn by the judge between the objective element of provocation and the defence of self-defence. And I mean, I think historically that's understandable, actually, as one comes from the other. And he explains the policy. Shouldn't be in our country that an accused person under those circumstances to do so, nor should it be a reasonable man to do so, to take a knife and stab the other person in return. Just explaining generally the principle of proportionate response. And then over the page at paragraph 9, the specific misdirection is a direction to the jury that they had to be satisfied that the retaliation must be proportionate to the provocative acts. And we obviously all accept that that's not right, and we shouldn't put it like that. But then, having considered the various authorities, including Camplin, Duffy, Cardinal Williams, Acott, all the big decisions, albeit in short order, the board reaches the conclusion it does in paragraph 20, halfway down. That is immaterial because their lordships are satisfied that the jury, having decided as a precautionary measure, the judge, having decided as a precautionary measure to leave the issue to the jury, his direction about the need for the retaliation to be proportionate was cured by the ensuing passage. From that, it must have been plain to the jury that his decision, that his direction that the retaliation of the accused must be proportionate was to be considered in the context of the reaction to be expected of the ordinary person. And then referring to the evidence, and saying that the jury must have regarded the pounding of his wife with a knife when she was defenceless and not touched him as something constituting too disproportionate a reaction to attribute to a reasonable man.
So even though the wrong formulation was used, it wouldn't have mattered in that case.
That's right, my Lord, yes. So, the misdirection was immaterial in circumstances where the jury would have understood their task, which was to look at whether a reasonable man might well have done what the defendant did, and in circumstances where there was very limited provocation. To pound his wife with a knife repeatedly was a method, a means or mode of killing that no reasonable man would have embarked upon. Not sick killing simpliciter. You look at everything. So that's all I was planning to say on the law.
You haven't discussed really the impermissible line of reasoning which is highlighted in Liang at paragraph 115 and which was said to necessitate the direction.
Yes.
Perhaps you could give us your
Indeed, my Lord,
submissions in relation to that.
So the impermissible line of reasoning is a phrase that's repeated a lot in the Marcelline judgment of the Court of Appeal. And it, indeed, my Lord, as you say, it's traced back to this part. So the line of impermissible reading, as the Hong Kong court interprets it, appears to suggest that it's just not open to a jury to simply look at the scale of the retaliation, considering it was out of proportion, and therefore that the objective question should necessarily be answered against him. That's an impermissible line of reasoning, which, in a sense, we agree, because if that's a rejection of the reasonable relationship rule, we agree. But the difficulty is the jump from that to the model direction, which is, I think it's at 114. Just closing, it's 124. There's the model direction that's then picked up in. Yes, so it's the model direction. Thank you very much, Daniel. So it's the model direction that's suggested at paragraph 124 that is then introduced by Marcelline into Trinidad and Tobago. And it expressly says, second line, it's not a question of whether that ordinary person might have reacted in exactly the same way as did the defendant. It's sufficient, were you to find, that the provocation would or might have caused an ordinary person to lose control and cause the death with intention. And we say, well, even if we agree that it's impermissible, the impermissible line of reasoning, if it's a rule.
Well, you say, I think, sorry to interrupt, but if I understood you, what's impermissible, it would be impermissible to reason you've inflicted 213 wounds, therefore necessarily
yes.
you can't have a provocation defence.
Yes, I agree.
But you say it isn't impermissible to take account of
yes.
That fact amongst all the circumstances.
Yes. So
there's no rule that says you must ignore the fact that there are 213 wounds. You can't have regard to it.
So yes, exactly. So I don't understand the link between paragraph 115 and the alleged solution to that at 124, which appears to go much further than that's necessary to avoid the impermissible line of reasoning. All you have to do with the impermissible line of reasoning is just explain to the jury that it's not a mechanistic calculation. It's an assessment of all of the evidence.
Yes, I mean, the test laid down by statute is do as he did, but it's not to be interpreted as meaning act in precisely the same manner as he would have, as he acted.
Whereas the authorities that we've looked at to almost use exactly those words may have been to cause an ordinary person is not a question of whether the ordinary person might have reacted in exactly the same way. Well, that is what the authorities say. We've been to those authorities. That is what you have to ask. That's why it's in here, because it's rejecting that reading. I mean, I have to go back to those, but that's what Diplock says you do ask. You ask whether a reasonable man might have reacted in the same way. That's what the words he uses. So this is rejecting the English approach, although it doesn't actually set it out and then reject it. It just goes around it by reference to Australian authorities on different bits of legislation and New Zealand's legislation. So it goes around it, but it is rejecting the English approach. And we say, for similar reasons adopted by the majority in Holly, that you can't do that because Parliament effectively entrenched the meaning in 1957 or when the Trinidad Parliament introduced the equivalent legislation there. Even more so in Trinidad, because that was introduced after the decisions in Phillips and those other Privy Council cases. It would have been doubly clear in the 1980s that that's what it meant. Now do you need to find one? So, my lords, that brings me on to the last 2 points on provocation, where the criticism of the judge to say to the jury, well, you need to look at exactly what the defendant did when you consider the objective, the reasonable man test. And I say that actually, that's right. You do. But I accept that it might not be helpful for a judge to say to a jury, you need to think about whether a reasonable man would have done exactly the same thing as the defendant. Because it might give the impression that he needs to, the objective man, the reasonable man needs to have committed precisely the offence in precisely the same way. And that's obviously not what is really being conveyed. What's really being conveyed is the sort of thing the defendant did is the sort of thing an objective, reasonable man might have done if they were faced with the provocation, the gravity of which was experienced by the accused and his particular frailties in respect to the gravity. Was not a very punchy way of putting it, but yes, I do accept there are more helpful ways in which you could express the point. But what I would also say is the judge was very clear that it was for the prosecution to disprove all elements of the test. And I'll just give your lordships the references. So electronic bundle page 276, 283 and 284. There's particular pages of the summing up where the judge does explain that it's for the prosecution to disprove all elements and not for him to prove anything. But also just to bear in mind, in the context of this complaint about the judge's directions on the objective test, that when your lordships read the full summing up, if you haven't already, but when you do read the full summing up, it becomes very, very clear from reading it all that the main issue at the trial was not the objective test. The main issue at trial was whether the appellant's story about still being with Miss Miller, still being in a relationship, turning up at the house and being shocked to find her in bed with someone else and losing it, finding the cutlass there and then just losing the plot and not being able to remember anything else. That was actually the focus of the trial. That was the real thing that the jury were thinking about. That's very clear if one reads the summing up and looks at the way in which the respective cases are put. It's did they accept this story? Now we know obviously since that the story was a lie, but at the time obviously the jury was, it was an arguable point and it was put for the jury, but that was their main focus really. I mean, it is pretty obvious, respectfully, that they just rejected that. But anyway, I can't get away from the facts. I'm not saying that overrides the responsibility of looking at the directions closely and making sure they're correct. But it's worth bearing in mind that the true focus of the trial was not whether this response was proportionate. It was whether actually he was telling a bunch of lies or whether he might have been telling the truth about being surprised to find her in bed with somebody else. Or whether, since he's since admitted, he planned the, this was a pre-planned attack, effectively. He picked up the cutlass and went there, having threatened to kill them, and then did exactly that. Final point, there was a discussion about whether, if the expert evidence is admitted, it adds anything to the provocation case. And we say it plainly and obviously doesn't. Because if the expert evidence goes in, he accepts both to Dr. Latham and to Dr. Attard that he went to the house with a cutlass. He threatened Lawrence Stewart, and he threatened to kill both Lawrence Stewart and the victim earlier on the same day. He threw bottles at Mr. Stewart and said, "Stay away from my girl," or words to that effect, threatens to kill them, goes and gets a cutlass, then turns up at the house and does exactly that. He obviously knows they're in a relationship together. He says to his 2010, he says in the 2010 notes to his counsel, he says, she moved out to go live with Lawrence. She left.
Well, he threatened Lawrence on the street that day. That's part of the evidence.
So the provocation case that the jury has to consider then becomes, here the appellant is seeing his ex-partner in bed with her fiancé. He then cuts them up, having gone there with a cutlass. That a provocation case does not make. I mean, this isn't part of the fact there's no provoking act. There's nothing there to go to a jury. The judge would be perfectly entitled to withdraw that provocation case from the jury, and this board is entitled to apply the proviso. That's hopeless. You can't be provoked by seeing your ex-partner in bed with a fiancé. And in any event, even if that did give rise to an arguable case of provocation, it would fail on the reasonable man test. Because no jury in Trinidad is ever going to accept that a reasonable man, having seen his ex-partner in bed with her new partner in a different house months after leaving him, justifies chopping her up. And that doesn't depend on the Hong Kong judgment. Whether it's...
But is that line open, given the requirement to leave it to the jury, the question?
Well, at this stage, it's proviso territory. We're saying that there's nothing to go back. So even if the expert...
Well, what's the difference between that and withdrawing it from the jury? I mean, that is saying that the jury couldn't come to that conclusion.
Yes. So
But, I mean, is that... Can you do... I know you can normally say that, but does the...
Yes.
Can you say that on the objective question under this statute?
I think we say yes, because the proviso is what governs this board's powers, irrespective of if at trial the judge would have to leave it to the jury. But that doesn't mean this court has to. This court doesn't have to send back a completely hopeless case of provocation and completely hopeless evidence just because there's a provision that says a trial judge has to do that.
We would have to be certain that there was no miscarriage.
Oh, yes. You can't be much more certain than that. I mean, you threaten them in the morning, you pick up a cutlass, you go there and carry out the threat. I mean, no juror in the world is going to buy that. You can be absolutely certain that that case can't possibly succeed. It's hopeless. Anyway, that's what we say about provocation. Anything on provocation? No. Right. So, looks like nobody's telling me that they're going to leave the room and come back in 5 minutes. So I'll just carry on.
No, we want to hear you on. We want to hear you on diminished
This
responsibility.
happens to me so often. These right. Okay, fine. So diminished responsibility. What I would like to do then, please, is just have another quick look at the legal principles governing the admission of fresh evidence, bearing in mind, as we do, that Section 23 of the Criminal Appeal Act in England, Criminal Appeal Act 1968, and the test in Section 47 of the Supreme Court of Judicature Act in Trinidad are basically the same. The Section 23 has included within the provision as amended various bits of the case law or things that the court can and can't consider, but the fundamental test is if they think it's necessary, expedient in the interest of justice to receive the evidence. And Section 47 says, Court of Appeal may, if it thinks it's necessary, expedient in the interest of justice, receive evidence. So it's a broad interest of justice test, as I understand. One decision that's cited quite frequently before the board is Erskine. It's at EB 1198. Tab 37 for those of us still on paper bundles. Quite a long head note, but I would respectfully just invite your lordships please to read the 2 pages of that head note. I'll just emphasise, obviously, in Mr. Erskine's case, even though he had not run the point at trial, the evidence was so strong that he was suffering from schizophrenia and a psychiatric disorder, which not only diminishes responsibility for the offending, but also explain why he hadn't run the point at trial. So some medical evidence may be of disorders that are so pervasive and clear that they actually just explain the lot. But other cases, like Mr. Williams, not so. In his case, a different result was reached. In particular, in respect of the unconvincing evidence as to potential mental impairment at the time of the killing. They're no more than factual examples. I'm not trying to draw anything more from them, but just so we can understand the context of the case. And what we say is a broad, very fact-sensitive test. And certainly if one turns up paragraph 22 of the decision, which is at page 1205 of the bundle, paragraph 22, you can see how the behaviour of Mr. Erskine certainly should have been ringing some pretty loud alarm bells at trial and prior to the trial at the police interview. And then I'd like to turn, please, to paragraph 39, which sets out the full test in section 23, and in particular the considerations in subsection 2, which don't appear in Trinidad, I believe. Is that right? Thank you. And then the first bit, the interests of justice, do. But these extra considerations, which I'm assuming effectively codify cases, I suppose, do. But anyway, I don't think they take the point necessarily that much further. But the real point is that D, virtually by definition, the decision whether to admit fresh evidence is case and fact specific. It's a wide one. A wide discretion focusing on the interests of justice. The fact it wasn't produced at trial, I accept, does not automatically preclude its reception. It's well understood, save exceptionally, that if the defendant is allowed to advance an appeal or defence or evidence which could and should have been put before the jury, the trial process would be subverted. And then finally, where the issues could have been but were not raised at trial, unless a reasonable and persuasive explanation for one or other of these omissions is offered, it's highly unlikely that the interests of justice test will be satisfied. And one can understand why that is so, because it's very easy for a defendant to run one point at trial, lose, and then think, right, now I'm going to run a different point. That had I run that different point at the same time as the first point, they would have conflicted, they would have caused problems, they may well have... So I made an election, in other words, and then to come along later and say, well, actually now I want to run a different point. So that's why, in cases such as this, the focus is on understanding, well, what happened at the time, why wasn't it run? Why is it being run now? And is there a good reason to put aside the concerns about finality, victims, justice, all the rest of it, and reopen a case? And it's worth bearing in mind the point at paragraph 42 that...
This broadly will be the test that the Court of Appeal in Trinidad required to apply. As well, to Mr. Fitzgerald, we should apply the Lundy test.
Yes, well, yes. Well, that's very timely intervention, respectfully, my lord, because we don't forcefully disagree or have any sort of major problem with the court looking at Lundy and considering it through that lens. But that case has taken on something of a life of its own because it was referred to in Edwards' decision of the board from Jamaica as the leading case on the admission of fresh evidence. But we'll look at that case in a moment. I'm not sure, with the greatest respect, it was ever intended to be such, because there's a series of very important cases directly from Trinidad at the Privy Council level, reported decisions dealing with the actual test in Trinidad, which doesn't quite result in where you get to in Lundy. So we are placing, we're not causing a big, but I don't think it's necessarily right to treat that as the litmus test of the admission of fresh evidence in these sorts of cases. Lundy was a case where the fresh evidence spoke to the probity of the evidence that was led at trial. So it's a brain tissue case. And it was the analysis of the brain tissue case at trial, which was then called into question by later evidence. And the same in Edwards. It was a new evidence going to the probity of the trial evidence. But these cases are different. These cases are about fresh evidence on fresh issues. They're grappling with something different, and there's a lot of well-trodden authorities at the highest level dealing with the admission of evidence in those sorts of cases that I don't want us to just sort of ignore.
Sorry to ask a rather basic question, but is there an equivalent in Trinidad of Section 23 of the Criminal Appeal Act, or what are we operating under here?
Yes, so it's
Is it in the same words?
It's Section 47. So if your Lordship looks at the words of Section 23(1) in England, which are extracted at paragraph 39 of Erskine,
Yeah.
and then in the authorities bundle. Hello?
It's in the supplementary authority section.
Oh, is it? Sorry. It's in the...
Tab one.
Thank you very much, Ed. So, Section 47 of the Supreme Court of Judicature Act is then in the supplementary bundle at page 3. And it's effectively, if one takes out all the unnecessary words, the same test, if it thinks it necessary, expedient in the interests of justice to receive the evidence.
Sorry, what page was that?
Page 3 of the supplementary authorities bundle. So there's a synergy between the test applied in England and Wales and applied in Trinidad, although in England and Wales, and not in Trinidad, Section 23 gives a series of considerations. It expressly sets out a series of considerations, whereas in Trinidad it doesn't. But certainly Erskine has been cited in several leading Trinidad Privy Council appeals. Pittman, Chandler, Richard Brown, maybe Richard Brown might be Jamaican. Anyway, we'll come to that. But there is, my lord, yes, there is a purpose to going to these cases, yes, because there is a synergy between the sorts of considerations that apply. Mindful, I accept the point that will be made by my learned friend, which is, well, you do have to take into account the context and nature of trials, because trials in England and Wales that this case discusses do involve mandatory testing of defendants for mental health concerns and so on, whereas you don't have mandatory testing in Trinidad. And therefore, the question of whether to seek a report in Trinidad is led by an evaluation of the history of medical symptoms, the presentation of the client and the facts that they are speaking to about the killing, and any evidence that you then think you might get on the basis of that. So it's a different scenario in that regard. And of course that does reflect, my learned friend will say, and I can see the point to some extent, it does reflect when you're looking at reasons for not running the point at trial. because you're only going to run the point if there's something coming at you that makes you think as a trial lawyer, oh, I better get a report. Paragraph 42 of Erskine refers to Campbell number 1, Colin Campbell number 1, emphasising that diminished responsibility, unlike provocation and most offences, is an optional defence. So it's not one of those defences that the trial judge has to say, oh, I can think that the evidence might well give rise to this defence, therefore I have to put it. It has to be coming from the defendant. And again, paragraph 46, the extract there, which I hope just saves me having to go to the individual cases. Erskine, by the way, considered just about every case in the world ever on this issue and provides a summary of what they all say, and then says at the end that people shouldn't do that anymore. And this will be the last time it's done, because all you need to do is look at the section and look at the words and apply it. But anyway, that's context. But it's the point there in the extract at paragraph 46 at letter F. Defendants must advance their full defence before the jury and call any necessary evidence at that stage. It's not permissible to advance one defence before the jury, and when that's found, to devise a new defence, perhaps many years later, and then seek to raise that defence on appeal. And then briefly over the page at paragraph 48. There, the explanation for the failure to advance the defence at trial was to be found in the very mental condition of the defendant himself. So that's another case like Erskine, where the disorder itself explains why he didn't run the case at trial. And then Pearson case, which is an important case at paragraph 51. That's the judgment of Lord Bingham, Chief Justice at the time. And the important considerations that Lord Bingham suggested may be relevant, extracted at F. Deliberate decision by a defendant whose decision-making faculties are unimpaired not to advance defence known to be available. That's not us. Obviously is mentally impaired, but evidence of mental abnormality or substantial impairment given years after the offence and contradicted by evidence at the time. Well, maybe. Expert evidence based on factual premises which are unsubstantiated, unreliable or false, or which for any other reason are unpersuasive, which we do say respectfully is this case. He's given at least 3 different accounts of the killing. But in any event, I do accept that in the end, this is really the point made at G to H, that the statutory discretion could not be constrained by inflexible or mechanistic rules. And this is why we do have a bit of concern about Lundy, because it does appear to say, well, if this, and if that, and if this and that, then the other. And we do say, not sure that does actually fit quite with the breadth of the discretion here. Anyway.
On the other hand, the Section 47 does seem to be written in very broad terms, broad and general terms.
Exactly. And deliberately so, we say, because you've got to look at every single case on the facts, and whilst broad reference to certain categories of consideration, such as those explained by Lord Bingham, might help you, it's not necessarily helpful to do what they do in Lundy in a different statutory context, and say, well, if this is the case, then it goes in. If that's not the case, it goes out. If it's somewhere in between, then this is the question. However helpful it might appear to reduce it to that kind of mechanistic test, we say that's not really fitting with how these provisions have been interpreted in the past. I've got a massive issue with it, as I say, because I do think, and we'll go to it in a second, that it does touch on the same correct broad considerations. But there's just a sense on this side that maybe that decision is sort of gathering a momentum that just needs to be checked slightly, just to make sure that there's no reference by Lord Kerr and Lundy to any of these decisions, by the way. Anyway, that's basically paragraph 61, just before I finish. Paragraph 61, the more unpromising the context in which the appellant seeks to adduce fresh evidence, the more compelling the evidence would have to be, other things being equal, for the Court of Appeal to receive it. Each case will depend on its own facts. Explanation for the failure to adduce the evidence which would have supported diminished responsibility at the time is important, and that's about all I need from that case. So I think I can leave it there with your leave, and then come back at 2 and start with the case of Chandler.
Yes, very well. We'll adjourn then just now and resume at 2 o'clock.
My lord, thank you.